very good evening and a warm welcome to all of you at the book launch of our new publication, Parliament, Powers, Functions and Privileges, a comparative constitutional perspective, authored by Sri K.S. Chauhan. Today, it is an honor and privilege to have with us our chief guest, His Lordship, Honorable Mr. Justice P. Sathasivam, Chief Justice of India. Honorable Mr. Justice T.S. Thakur, Judge, Supreme Court of India. Distinguished guests, Professor Dr. Ranveer Singh, Vice Chancellor, NLU Delhi. Professor Dr. K.L. Malai, Director, School of Law, IGNOU, along with our author, Dr. K.S. Chauhan, Advocate, Supreme Court of India. Other distinguished guests, and our friends from legal fraternity and media. We will now be presenting the bouquet to our esteemed guests. May I request Mr. Mohan Ramaswamy, Managing Director, LexisNexis, to present the bouquet to our chief guest, Honorable Mr. Justice P. Sathasivam. I will now request Mr. Amitabh Srivastava, Senior Director, LexisNexis, to present the bouquet to Honorable Mr. Justice T.S. Thakur. I will now request Mr. Vikesh Dhyani, Senior Director, LexisNexis, to present the bouquet to Professor Dr. K.L. Malai. I will now request Mr. Vikesh Dhyani, Marketing Director, LexisNexis, to present the bouquet to Dr. K.S. Chauhan. I will now request Mr. Vikesh Dhyani to present the bouquet to Professor Dr. Ranveer Singh. Call upon Mohan Ramaswamy, Managing Director, LexisNexis India. At LexisNexis, Mohan is actively driving consolidation of our offerings in legal and professional, expansion of our presence in both print and online, diversification into new markets like academic and tax, while maintaining a strong focus on quality of authorship and publishing. Mohan's last assignment was as the CEO of Dun & Bradstreet in India, where he held several roles ranging from business development, mergers and acquisitions, new market and product development, to operations and overall P&L management. I would now request Mohan to deliver the welcome note. Sir.
Our guest of honor, Honorable Justice T.S. Thakur, Judge, Supreme Court of India. Our distinguished guest, Professor Dr. Ranveer Singh, Vice Chancellor, NLU Delhi, and Professor Dr. K.L. Malai, Director, School of Law, IGNOU. Our author, Dr. K.S. Chauhan, Advocate, Supreme Court of India, Honorable Judges of the Supreme Court and Delhi High Court, members of the Bar, and other senior advocates from Supreme Court and Delhi High Court, our friends from the media and the legal fraternity. Once again, a warm welcome and a very good evening to all of you, and many thanks for gracing this special event with your kind presence today. As you are aware, LexisNexis is one of the leading global providers of content-based solutions designed specifically for professionals in the legal, risk management, corporate, government, law enforcement, accounting, and the academic markets. Part of the Reed Elsevier Group, the LexisNexis legal and professional business serves customers in over 100 countries and with over 10,000 employees worldwide. We've been in India for about 15 years now and have proven and respected brands like Butterworths, Halsbury, and Lexis India, which is our online legal research solution with online commentaries from leading authors and experts like Mullah, Sarkar, Wala, Palki Wala, etc., all linked with the requisite case laws and central acts. Lexis India publishes, LexisNexis, publishes about 150 odd new works each year in print and has been rapidly expanding its presence in the online space as well. Competent and talented team of professionals with strong legal background drive our commissioning, editorial and the overall publishing calendar. We have a very strong marketing and sales teams that make sure that the legal books published by us are made available to a network of over 2,000 booksellers in India, apart from directly promoting our books to different end users through massive electronic and social media campaigns, besides several other event-based marketing. Let me now cover a bit about the book. Parliament, Powers, Functions and Privileges is focused on the Indian polity with comparative insights of practices and experience of various liberal democracies. India, having given itself a basic governing document in the form of the Constitution, is an apt model of a nation state to be imitated and followed. The Parliament of India, having its origin from the Constitution of India, is a supreme legislative body which reflects the representative democracy elected by an adult suffrage in a free and fair election in tune with constitutional principles. The literature on Parliament, its working and functioning is in abundance. However, we thought there was a vacuum in the existing pool of literatures which covers all the three important aspects, that is powers, functions and privileges. This book is therefore a modest attempt to fill the existing vacuum in the world of academia. The Parliament of India is a magnificent manifestation of the democratic ethos, and it is the repository of the constituent power which occupies central position in the Indian democratic polity. This voluminous work begins with a narrative on historical evolution of parliamentary institutions in England and India, powers and functions of the Parliament, elections of its constituent members. The chapter on privileges and media is a special highlight of the book, which also examines the role of media vis-a-vis parliamentary privileges, issues of sting operations, its limitations, etc. I'd like to congratulate Dr. K.S. Chauhan for this wonderful new book that aims to cater to the needs and demands of understanding the Parliament as an institution of national importance and bedrock of Indian polity. It would be useful for the members of the bar, bench, policymakers, research institutions, libraries and law students. Besides this, it also seeks to attract readers from various segments of the society so as to understand the powers, functions and the overall privileges of the Parliament. I'd like to thank all our guests for agreeing to grace this wonderful event. This is the second book launch this month where His Lordship, Honorable Mr. Chief Justice P. Sathasivam has consented to be our chief guest, and we hope to have him grace our other book launches as well in the future. Thank you very much and enjoy the rest of the evening.
Distinguished guest and speaker is Professor Dr. K. Malai, the present Director of School of Law, IGNOU.
Very warm welcome and good evening to all of you. Honorable Mr. Justice P. Sathasivam, Chief Justice of India, Honorable Mr. Justice T.S. Thakur, Judge, the guest of honor of today's function, Honorable Mr. Justice Sallameshwar, Judge, Supreme Court of India, Professor Dr. Ranbir Singh, Vice Chancellor, National Law University, and Mr. Vijay Kumar, Acting Vice Chancellor, Ambedkar Law University, Tamil Nadu, and Mr. Jaswal, Vice Chancellor, National Law University, Patiala, and other distinguished guests, friends, ladies and gentlemen. Really, I feel proud and honored to stand before you as a person who had an occasion to scan through the earlier manuscript of this book to make introductory remarks among this august gathering assembled here to witness the release of the book titled Parliament, Powers and Functions and Privileges, a comparative constitutional perspective, written by Dr. K.S. Chauhan. Doctor, just before I make a reference about the books, the contents very briefly based on my memories, I also would like to say a few words about the author. Dr. K.S. Chauhan, as we all know, is an advocate practicing the Supreme Court of India, who among other credentials has conducted a famous case on parliamentary privileges, popularly known as the cash for query case, that is Raja Rampal versus the Honorable Speaker of the Lok Sabha. I think the petition is also present here. In the year 2007, before the Constitution bench of the Supreme Court, many amongst gathered here may not be aware of the fact that Dr. K.S. Chauhan has earned his doctoral degree by working on the subject Problems of Defections and Indian Constitution, a study on emerging trends. I think the guide is also present here. Dr. K.S. Chauhan make a reference about him also. Work done by him, emerging trends, which has close nexus with the upbringing of this book. Another distinct work done by him as a fellow or parliamentary fellow at the Institute of Parliamentary Studies was on the jurisdiction of the Supreme Court of India. A combination of the above briefly stated but continued research exercise carried out perhaps enabled him to come out with a book of this kind, that is Parliament, Powers and Functions and Privileges, a comparative constitutional perspective, a much needed exercise at this juncture. Now let me recollect my memories from the manuscripts about the book. We have come across adequate literature on various aspects and functioning of the Parliament. However, how it evolved over a period of time, we could not come across. But Dr. K.S. Chauhan took the pain of tracing out the evolution and the constitution, evolution of this Parliament, this highest institution, over 1,000 years, that is since the 11th century, he has traced out the evolution and development of the Parliament, which I am sure at least I can admit my ignorance on this. I have not yet come across any such book which gave the detailed analysis about the evolution of this institution, highest institution, over a period of 1,000 years. And this author tried to wipe out this gap by exclusively developing a chapter on Parliament evolution development from this. That's what I have heard about this. The next important thing is Article 79 of the Constitution of India deals with the Constitution of Parliament. I quote, there shall be a Parliament for the Union which shall consist of the President and two houses to be known as respectively as the Council of States and House of the People, unquote. With a view to do justice to the title chosen on the one hand and fulfillment of one of the requirement of Article 79 of the Indian Constitution pertaining to the President, Dr. K.S. Chauhan devoted exclusively 2 chapters on the President's, on the powers and functioning, limitations, and also the election procedures, all these details and all. Again, in Indian setup, not scant attention is important to the importance given to the role, functions, and powers of the President is concerned. But Doctor wanted to be an exception to this, understanding the percentage ejection, the role and the importance of the President. Perhaps he has done justice by devoting 2 exclusive chapters on the President of India, one dealing with the powers, functions, including the limitations, and all the electoral process, giving the various governments of all those things and all. Let me state very firmly, to be very specific, that he has dealt with powers of the President, including the limitation on his power, relations and difference between Lok Sabha and Rajya Sabha, comparative study of the same in several countries, UK, Canada, USA, and above covered in this chapter. The author has also made an attempt in brief to explain the relationship and differences among the presidents of India, America, and UK, that is the king, in the following words. I quote, being a republic, India cannot have a hereditary king. So an elected president is at the head of the executive power in India. Again I quote, he, that was the Indian president, I quote, he resembles the American president in as much as he is removable by the legislature only under the special quasi-judicial procedure of the impeachment that is under Article 6 of the Indian Constitution. But on the other hand, he is more akin to the English king than the American president in as much as the Constitution entrusts to him no function to discharge on his own authority. Again I quote, in addition to the in addition to the electoral process involved in the procedure to be followed in the election of president, vice president, including the eligibility formula for election, systems of proportional representation by means of single transfer vote, etc., has become dealt with in this elaborately. Then the remaining two aspects of the Article 79, that is other than the president, which squarely falls over the parliament, Dr. Chauhan has also elaborated dealt with the powers and functions of the parliament. In chapter 4, he deals with the parliament powers and functions. The book with all the powers of the parliament, such as deals with legislative power, power to establish additional powers, residuary powers, constitutional powers, that is the amending power of the constitution, comparison between amending process in USA and India, the theory of basic structure, power of impeachment of the president, vice president, power of removal of the control and auditor general officer, chief election commissioner and other constitutional bodies, removal of the judges of the High Court and Supreme Court. All these aspects we have dealt with elaborately. The other important aspects such as the disqualification of members of the parliament, including defection as a disqualification, are also broadly dealt with under the chapter 5 and 6 of this book. The grounds of disqualification of members due to holding of office of profit has been adequately dealt with by referring to leading cases, case laws and relevant legal provision. Again, these days, with the view to accommodate more and more members who could not get the ministerial bar, they have been accommodated in many of the next level bodies and all. Whether it falls under squarely on the office of profit or not, that aspect needs to be dealt with elaborately. I think Dr. K. Chauhan, the author, has done elaborately good work on this particular subject, which is very, very important, relevant at this juncture. The notable contribution made by the author in the subject defect is the compilation and consequences of various defections taken place in the country since the beginning of that. He has given a complete history of how the defections take place, not only states at various levels also. It's a remarkable work done by him. The book also illustrates the position of the defection in various countries such as the UK, Australia, Brazil, USA, Russia, Italy. The parliamentary privileges is another important subject which elaborately dealt with in this book by making reference to history of the parliamentary privileges, pre-independent post-constitution era, comparative study on parliamentary and legislative privileges in various countries. Then in India, the next important thing is the judicial review and the parliamentary privileges. That is another important. Any student of law, we cannot afford to ignore the subject judicial review, particularly the constitutional framework is concerned. Parliament no doubt has the power to make law, but certainly does not possess the power to enact the law which is unreasonable or arbitrary in nature or contrary to the procedure established under the law. Similarly, Parliament has the power to amend the Constitution, but certainly does not possess the power to change or alter the basic structure of the Constitution as held by the Supreme Court in the infamous case of the Chauhan and the Bharati. The excess of power by the Parliament beyond its scope and ambit can be checked by the High Courts and Supreme Courts through the power of the judicial review conferred upon them under the Constitution of India. The above aspects elements in relation to parliamentary privileges made available to members of the Parliament have been discussed at length in this book by referring to various relevant case laws in India as well as abroad. That's another important substantive work done by this author as far as this book is concerned. Then again the growing area is the parliamentary privilege and the media. Now due to the emergence of the electronic media, now it has become all the more difficult to bring a balance between the privileges of the members of the parliament as well as the privileges enjoyed the press also. Like the members of parliament enjoy certain immunities and privileges, the press has also certain privileges while discerning influence to the public. In the event of conflict between the said privileges enjoyed by both the pillars of the democracy, it will be a difficult task to resolve such a conflict. This aspect has been elaborately discussed in the book by referring to sting operations carried out in India in certain cases, in addition to referring to several relevant laws and case laws, including that of foreign countries. Last but not the least, the author has covered an exclusive chapter on this by including the case law on expulsion of case law of Raja Rampal, a member of the parliament to the court in an elaborate way. This is a new addition I come across. Normally the law books have the case law, but he has given the case study about the entire case dealing on the dimensions of this. Because I am sure the gap exists in the academic world. Now this book will be very, very useful not only to the law students, teachers and practicing advocates, also to fill the vacuum that exists. With these few remarks, let me thank the publishers and the author for considering a person to make a introductory remarks on this project. Thank you very much for all of you. Please.
I would now like to call upon our author, Dr. K.S. Chauhan.
It is my privilege to welcome Honorable Mr. Justice P. Sathasivam, the Honorable Chief Justice of India, and express my gratitude to His Lordship for agreeing to release this book, Parliament, Powers, Functions and Privileges, a Comparative Constitutional Perspective. I am in fact indebted to my Lord the Chief Justice of India, who despite his very busy schedule and after devoting his valuable appreciation to the adjudication of 54 cases miscellaneous day, and also after presiding over a special bench post-length session, could agree to release this book. I am also indebted to my Lord Mr. Justice Thakur, Judge Supreme Court of India, who despite his very busy schedule encouraged me by writing the foreword for the book, and after devoting his valuable appreciation to the adjudication of 50 miscellaneous cases and 5 final disposal cases in the day, has agreed to preside over this function. My Lord has always been kind enough to promote the academic endeavor like the present one. The Supreme Court of India, Mr. Altaf Ahmed, Senior Advocate, Mr. Rakesh Khanna, Additional Solicitor General, Maninder Singh, Dr. Julian, and all the most Mr. Raja Rampal, because of whom I could write this book, because he has entrusted his case to me, and at my level I am also thankful to my teacher, Professor Dr. Hon'ble Singh, Vice Chancellor, National Law University, under whose guidance I completed my PhD, for his support and his suggestion for the improvement of the content of this book, and for gracing the function in spite of his very busy schedule. And I also acknowledge the presence of P.S. Jaswal, Rajiv Gandhi National Law University, Patiala, Vice Chancellor, and Professor P. Vijay Kumar, Vice Chancellor, Dr. Ambedkar National Law University, Tamil Nadu. I also acknowledge the presence of Professor Mane, who was Head of Department of Bombay University. My own behalf as well as on behalf of my publisher, welcome each one of you to this book launch function. This book is on the constitutional aspect of parliamentary system of governance, which Constitution of India seeks to establish broadly on the pattern of British parliamentary governance. However, the proliferation of democratic values and constitutional governance based on the principle of liberal democracy across the globe, coupled with the phenomenon of globalization, has changed the landscape of legal research and legal system itself. The reliance placed on the comparative resources by the judicial body, including the Supreme Court of India, on numerous questions of law has become the norm of the day. Similarly, the decision of our court's interpretation given by it on various issues of constitutional governance are being relied, incorporated by the foreign courts. Taking stock of this existing reality, increased interaction among the judges, the jurists, lawyers, academicians, legislators, policymakers, research scholars, I have made an attempt to analyze the subject matter of parliament, power, functions and privileges from a comparative perspective. The Parliament of India is the supreme legislative body which reflects the representative democracy elected by an adult suffrage in a free and fair election in tune with the constitutional principles. The working of constitution based on the principle of separation of powers, which seeks to establish rule of law, the working of Indian Parliament and its working with other branches, the legislature as well as executive inter se, present a unique case to study. The literature on Parliament, its working and functioning is in abundance. However, in the existing pool of literature, we may call it treaties, books, compendium, cases, materials, etc. on the working of the Parliament, which covers all the three important aspects: powers, functions and privileges. The modest attempt to fill the existing vacuum in the world of academia. The Parliament of India is a magnificent manifestation of democratic ethos, and it is the repository of the constituent power which occupies central position in the Indian democratic polity. The voluminous work begins with a narrative on historical evolution of the parliamentary institutions in England and India, constituents of Parliament, their relationship and elections to various parliamentary offices and powers and functions of Parliament. I have also dealt with disqualification of members and the principles of anti-defection law inserted through the Constitution 52nd Amendment Act 1985 has been dealt separately in a chapter titled as defection as disqualification. Apart from this, the book makes an in-depth analysis of the origin, purposes and constitutional practices of parliamentary privileges, outline the height of tension between the office of the Speaker of Lok Sabha and the Supreme Court in cash for curie case. The judicial review of parliamentary practices and privileges has been dealt very exhaustively in this as the area where the overarching principles like separation of power, judicial review and rule of law interact very intrinsically with each other. The chapter on privileges and media is a special highlight of the book, which also examines the role of media vis-a-vis parliamentary privileges. The issues of sting operation and its limitation, etc. is also dealt in this book. It is a popular saying in the House of Commons that the privileges of the House and its members are not unlimited, but they are nonetheless established as a matter of parliamentary law and practice and must be respected by the courts. Judges must look to the Parliament for precedents on privileges, not on the law judges, since it is in Parliament where privilege is defined and claimed. The book also contains a separate chapter on Radharam Pal case, cash for curie case, an occasion when two branches of the state under the constitutional governance confront each other and consequently a tension emerges out, sending a ripple across the administrative web, having impact on very fabric of the constitutional governance. In recent years, Radharam Pal case is the one of such case which I conducted before the Supreme Court of India. The case witnessed scandalization of the institution of Parliament and its members, who are duly elected by the people through the sting of media, on an issue of corruption which undermines the rule of law. Defiance of the office of Speaker to submit before the jurisdiction of the apex court, which is the final arbiter of any dispute emerging on constitutional issue. If we go to the principles, even they have sovereignty, but there the House will provide all the information to the court. But in this case, the House has not provided any information. Because in the case of my client, unusual thing, the 5 questions which were posted in the Lok Sabha, they were rejected by the Lok Sabha, saying that signature of my client does not tally. But still he was expelled. a person who has not signed the questions for the allegation that he has taken bribe, and in the sting operation itself he is saying that I will prosecute you because you have lost four questions for this. So the lady is saying, no sir, मैंने नहीं किया. She is naming somebody else. He must have done it. The role of Parliament and the media in communicating parliamentary activity to the citizen is also essential and franchise. The public and the media provides a conduit which a public occasion is communicated to the members of Parliament. Parliament recognizes the right of media to have access to the institution and to the parliamentary processes and to report on them, as the right of free speech is one of the greatest guarantee to liberty in a free country. However, even in the developed countries, the regulatory mechanism is provided, and even they hold their convention which are not open to the media. The legislature has to see the necessity of the privacy in discussion on important national issues or other issues relating to security of the state. The purpose limitation on the media is to strengthen the democratic values and not to restrict such values. I have dealt with the diversity of media outlets in foreign countries like Canada, UK, but the citizens still receive their news from a narrow range of sources, especially television. I hope the book would cater to the need and demand of understanding the Parliament as an institution of national importance and bedrock of Indian for the members of the legislative houses, bar, bench, policy makers, research institutions, libraries and law students. Besides this, I hope that the book will find its acceptance and will be of use to the journalists reporting the Indian polity, students of political science and a vigilant citizen to understand the powers, function and privileges of Parliament. Before I sum up, I would like to mention Mr. Gopal Subramaniam, Senior Advocate, Supreme Court of India, who encouraged me in this endeavor by writing an introduction. Lastly, I must give full credit to my publishers, LexisNexis India, for bringing out the book and its editorial team for all their cooperation. I am thankful to Mr. Amitabh Srivastava, Sonia Patel, Ashish Bhadoria, Ishu O'Brien, Mr. Dhyani, and last but not the least, Mr. Mohan Ramaswamy, Managing Director.
Our next distinguished guest, he is the founding Vice Chancellor of National Law University, Delhi, and
Honorable the Chief Justice of India, Honorable Justice Thakur, Honorable Justice Chandrashwar, the other learned advocates, my friend Vijay Kumar, Jaswal, alumni, the LexisNexis people, Chauhan, other friends. The nation is worried the way the Parliament is functioning because the kind of time we lose in the Parliament, not for serious debates, but for disruptions is anybody's cause of concern in a nation democracy like ours. I begin with a quote of Blackstone. I think we have all the things to agree with, and he says, within quotes, the principal privilege of Parliament consisted in this, that its privileges were not certainly known to any, but the Parliament itself. Parliament only knows what are the privileges available to them and the way they can go, the limits they can assert those privileges. Friends, parliamentary privileges is one of the most important aspects of our working on the Constitution in general and the Parliament in particular, having inherited the British constitutional practice in the Constitution itself, till it was amended out the established constitutional conventions and the practices relating to parliamentary privileges based on British parliamentary privilege continue to exist even in India today. That's a big question. Should we carry on with those privileges which the British Parliament enjoys? Although the Constitution of India provides certain provisions, both the legislative privileges for the Parliament and the state legislatures, and as well as the legislative competence to legislate on those privileges, Article 1404, 15, Clause 3 on one side, and 193, 194, 3 on the other side, provide for the authorization of the Parliament and the state legislatures respectively to enact laws pertaining to the privileges of the House, the committees and the members thereof. Article 361A provides for the privileges of the legislatures in relation to the media and the press. Entry 74 of the List 1 and the 39 of the List 2 of the 7th Schedule provide the legislative competence of Parliament and the state legislatures respectively in enacting the necessary law pertaining to the privileges. A specific type of restriction in the interference by the other organs of the state is also provided by the Constitution. The judiciary cannot inquire into the validity of the proceedings, Article 122 to 12, and the legislature cannot discuss the conduct of judges, Article 121 and 211, except by way of discussion of the removal of judges, Article 2, 121. These provisions require a specific statute to be enacted by the Parliament and the state legislatures at least to inform the citizens in preventing them from violating the legislative privileges. Unfortunately, since the commencement of the Constitution, neither the Parliament nor any of the state legislatures has enacted any specific law on these issues pertaining to privileges. The Karnataka legislature, fortunately, probably was the first one to introduce a bill on this theme, and that also remained a bill till the lower house was dissolved and no further action has been taken on this so far. From the perspective of the legislatures, many conferences presiding officers have concluded against such legislation as it would limit the powers of the legislature, because the best thing is not to codify, because then you have unlimited privileges. There is a need to balance these two situations and impress upon the legislatures to take up the concerns and frame necessary laws in this regard. In this absence, specific legislation and the absence of the consolidation of the best practices, even evolution of constitutional conventions in this area has been very limited. It is because one practice could be overruled by the presiding officers, it is convenient to set up a new practice. These aspects require meaningful deliberation to pave way for a transparent and accountable legislature in India during the next 2 decades. In this context, publication of this book entitled Parliament, Power, Functions, Privileges, Comparative Constitutional Study becomes meaningful to create interest among these diverse stakeholders. Such a comparative analysis is very important, helps the readers in understanding and appreciating the lacunae, if any, in the areas of the Parliament powers, function, privileges. This book is a meaningful divide, 11 chapters with the comparative inputs on various countries under each and every issue discussed in this chapter. Wonderful study. The concluding chapter on judicial intervention, the other Hon'ble mentioned, highlights the contemporary development taking place in India in the area of parliamentary privileges. I only hope that the law schools, colleges in this country will take the benefit of the vast amount of information contained in this book and continue to analyze the issues in a meaningful manner that would balance the interest of the Parliament and those coming into conflict with the powers, function and privileges. I would add a footnote. A great number of these problems mentioned in this book could be avoided if the legislative privileges are codified, to my mind. After all, the same has been done by the legislative privileges in other countries like South Africa, Zambia, etc. Finally, it must be emphasized that there is a need to stop relying on English parliamentary practices that have been born out of certain historical facts, very long time, which have never existed in India, and evolve healthy constitutional and parliamentary practices of our own. With this, I take my seat, and before I do that, I also acknowledge the presence of my dear younger brother and friend, Shri Bhagavan Deya, I can see him. He comes from all the above Rohtak to attend this function. Professor Dean and Head of Economic Department. Thank you very much.
This august gathering is blessed to have the presence of Honorable Mr. Justice T.S. Thakur, who not only wrote the foreword of the book in an erudite manner, but in a lucid yet indomitable style, for such a contribution to the book by his lordship. Our judge is known for his judgment and decisions, and in the Indian scenario, the judgment of the Supreme Court becomes the law of the land. The wisdom and far-sightedness of Honorable Mr. Justice T.S. Thakur can be gauged from the proposition of law laid down in a recent decision titled as Ankush Shivaji Gaikwad versus State of Maharashtra, wherein it was held that there exists a mandatory duty on the court to apply his mind to question of awarding compensation to the victim in every criminal case. The jurisprudence of victimology and compensatory regime has been redefined through this decision. I will now request Honorable Mr. Justice T.S. Thakur to deliver the presidential address. Sir.
Mr. Mohan Ramaswamy, Professor Melai, my esteemed brother Justice Chalmeshwar, members of the bar, members from the academic world, ladies and gentlemen. As Chauhan very fairly and candidly admitted before you, on a miscellaneous day, if a judge of the Supreme Court is invited after he has attended to and dealt with something like 50 or 70 cases, heard about 100 or 150 lawyers, dealt with some final hearing matters, to come and preside over a function in which the subject is something which is not very familiar to him, it would be very easy for the judge to excuse himself. I would have left to myself, successfully done that. There was some reluctance on my part to be a part of this function where such erudite people, such learned people will be present to speak to them on a subject which is not in the realm of law but in a realm that is slightly different from what we deal with. But two things left no option. One was that the book will be released by the Chief Justice of India. So once the Chief Justice of India is present on a function and you are supposed to preside over that function, you have a very easy job, as most of the companion judges have in the Supreme Court. You simply say, I agree. So I thought my job is done. Chief Justice of India will deliver the address and I will simply stand up and say I agree. But then the speaking order has been reversed. So it is here I am called upon now to deliver a judgment unprepared on a subject where the Chief Justice of India should be the author of the reading judgment. The second aspect which eventually weighed with me was that a book, I feel, is something that can immortalize the author. There are people who, in search of immortality, they establish trusts, they create institutions so that they can live beyond their lifetime. But I have always believed, and it is well said, that if you want to really live beyond your own lifetime, either do something worth writing about or write something worth reading about. Dr. Chauhan has made this maiden attempt to write something which is worth reading about. And I thought that on a function where an author, a budding author, is going to be introduced to the realm of literature, legal literature, it will be injustice and unfair to him to say no. That precisely is how I am before you. I have written the preface, foreword of the book. I did go through the manuscript and I found that it is very articulate, it's very methodically presented. It is an excellent work of research by Dr. Chauhan. And he was bound to be there. If you have guides and mentors like Professor Hon'ble Singh, the work is bound to be of a very high quality. And having said that, may I tell you that it is very difficult to say something original. There is a Pakistani poet who has put it very beautifully. He says, "Tum aa jao to jhoom uthe is rimjhim ki sada, warna ye raat ye barsat nayi baat nahi. अंदाज़े बयां रंग बदल देता है सैफ, वरना दुनिया में कोई बात नई बात नहीं." So the way you present a subject, the way you present something is what appeals, what creates an impact. As both the speakers before me, Professor Hon'ble Singh and Dr. Chauhan said, there is abundance of material on what are the powers, the functions and the privileges of the parliament. There is no dearth of it, both in this country as also outside the country. But then, when you present the same very work in an attractive manner, in the manner in which you deal with it, it can still turn out to be a classic. We have seen people have written books which may make no original contribution to the existing thought. I may mention to you, Professor G.P. Singh has written a book on interpretation of statutes. Now, interpretation of statutes is something, the principles, the canons of interpretation are well known, but the way the book presents the subject, it is so very appealing and so classical that it has become a classic in the lifetime of the author himself. I am sure Dr. Chauhan's work will also in due course emerge and develop into that kind of a classic. This is the first effort made by him, and if he has guides and teachers like Professor Hon'ble Singh and others, I believe there are a number of other teachers who are present here, I am sure he will do a better job in the second edition, and the book will really be respected among the lawyers and the legal fraternity as a whole. We have in this country universal adult franchise. We are talking of parliamentary privileges. We need to have a look at the scenario that confronts us today. In an ideal situation, if all is well, if there is no governance deficit, a legislator's job or a parliamentarian's job would be confined to formulating policies or helping in the formulation of policies, in making of laws, and in being a bridge between his electorate and that forum, that great forum where he has been sent to represent them. That is the true job of a parliamentary representative. But what is the reality? What is the ground reality? The ground reality today is that because of the universal adult franchise and the kind of literacy that we have in this country, and because of the rampant corruption and the problems that face the society, there is a governance deficit. So for every little problem, the people look up to either the MLA or the member of parliament. If the member of parliament goes to a village, he is not asked, how many laws did you make in the parliament? He is not concerned. He doesn't understand what process, the legislative process is in the parliament. He will go to him, he will tell him, 2 months back, my goat was stolen and has not been recovered so far. So please tell the SHO to recover my goat. This is the problem that the electorate will present to him. And voter will expect the parliament member to go to the SHO or ring him up or the SP and give him direction that the goat should be recovered immediately and restored to the owner. He may even tell him, well, my daughter-in-law has gone away and is not returning to her married matrimonial home, so please do something and bring her back. Now these are the kind of problems. In the city, the voter may like the parliament member to ring up some institution, the chief of an institution, to get his son an engineering seat or a medical seat, or somebody may like to tell him to please go with him to the minister to get him a job. His son is now a graduate engineer, is not finding a job, help him get a job. Now these are not the duties of a member of the parliament, strictly speaking. He is not elected to do this. He is elected to do a different kind of job. But he is now today burdened by these kind of demands which eat into his time. So the result is, when important legislations are tabled on the floor of the House, you will find there is no quorum. You will hear the bell ringing very often. Why? Because you don't have the minimum strength present in the House to be able to discuss that issue. So the end result is that the quality of legislation or the participation of our representatives in that process by which we are eventually governed gets affected. I feel it is a great disadvantage. It is a great deficit in terms of the rule of law. Because rule of law is not just that the individual should not be punished without being found guilty, as Dicey said. The process of punishment must itself be in accordance with the procedure established by law. The rule of law also is that every organ in the society or every organ in the system, the democratic system, must perform his or her duty in accordance with the law or the constitutional provisions. These are various issues. I am sure these can be the subject matter of a separate seminar. This is the kind of the gulf between those who are supposed to represent you and those who have expectations on them. I take this opportunity to thank Dr. Chauhan for having given me this privilege of being here. I look forward to the second edition of the book very soon. I hope the book takes off quickly. I congratulate LexisNexis who have reposed confidence and who have staked their money on this young author who has done a wonderful job. I'm sure they will reap rich dividends. It's a great thing to encourage younger talent, people who must get a break. It is the break that matters. There are many people who are simply waiting for a break. But if people like LexisNexis give that opportunity and that exit to those who can do justice to the subject, I'm sure there is no dearth of talent in this country. Thank you very much, and God bless.
I now request His Lordship, Honorable Mr. P. Sathasivam, to address the audience. Sir.
Honorable Mr. Justice Thakur, Justice Shalmeshwar, my esteemed colleagues and judges of the Supreme Court of India, Mr. Amitabh Ahmed, Mr. Rakesh Khanna, Mr. Kanagaraj, Mr. Maninder Singh, Mr. Vijay Kumar, Dr. Chauhan, hero of the day, Dr. Malay, Director School of Law, IGNOU, Dr. Hon'ble Singh, Vice Chancellor, National Law University, Delhi, Mr. Mohan Ramaswamy, Mr. Amitabh Srivastava, Directors, LexisNexis India, other distinguished members of the bar, invitees, guests, ladies and gentlemen. When 2 weeks ago Mr. Chauhan met me at my residence by showing the book, I informed him there is no difficulty because I know Mr. Chauhan last 6 years at least, his ability
and the topic he has chosen. He has brought a book and I have gone through it, various topics. Readily I agreed. And only one thing I requested him, let it be after the court hours. And he has chosen Monday. Of course, one of the speakers mentioned Monday and Friday after 4 o'clock. If the doctor check up our health, both judges and lawyers, they may request us to admit in the hospital. Normally, we do more work on Mondays and Fridays, and of course, other 3 days, we leisurely hear the matters. It's a great pleasure for me to release the book authored by Dr. Chauhan on Parliament, Powers, Functions and Privileges, a comparative constitutional perspective. Dr. Chauhan, the learned member of the bar, deserves all admiration for his meticulous efforts in coming up with a comprehensive treatise on constitutional dimensions of parliamentary system in India. I had the opportunity of appraising the book earlier. When he met, he handed over a rough copy, and I must say the book presents an in-depth research and thorough analysis of all major and ancillary issues pertaining to parliamentary democracy. I record my appreciation for the commendable effort the author has put in consolidating law in one compendium without compromising on the depth of research. The author has chosen a right publisher, LexisNexis, which has remained popular with the bench and the bar on the strength of its sheer quality and the high standards maintained by it. During the rise of concept of constitutional government since 18th century, much faith has been placed in the ability of democratically elected parliament to deliver a form of government that meets the high hopes placed in them. Considering the pluralistic nature of the Indian polity, the representative of people, of Indian people in July 1947 took the momentous decision to adopt Westminster model of parliamentary democracy instead of American pattern of the presidential system. As a form of government, the democracy which is envisaged by our constitution, the parliament operates as nerve center of the national activities. It is through parliament that the elected representatives of the people ventilate people's grievances and opinions on various issues, enact laws, scrutinize the functioning of executive both on the floor of the house and through special committees constituted for the purpose. The most noteworthy accomplishment of the decades of our freedom is that we have sustained the vitality of our parliamentary democracy, which has survived regardless of many hindrances that were not conducive to its well-functioning. India is the mother of modern democracies, as 2,500 years and more ago, the rudiments of parliamentary practice of the present day were found in the assemblies of Buddhists in India. No wonder India experienced democratic governance enjoyed worldwide acknowledgement, and our multicultural society is standing exemplar for those struggling to resolve the intricacies of race, language, religion and culture. The Constitution confers very significant powers on the Parliament so as to enable the elected representatives to realize the dreams and ambitions of the people of India. In this context, the duties and responsibilities of a member of Parliament entail the freedom of speech and action greater than one who enjoys as a citizen of the country. And for this reason, our Constitution confers certain privileges on legislative body and its members. And in order to ensure a smooth exercise of power and privileges, nowhere is procedure so decisive or so binding as it is in the Parliament. This is rightly so because unless discussion and debate are strictly controlled and procedural requirements for transaction of business are strictly adhered to, it would be impossible to transact all the volume of business it now manages to put through. The author proficiently touched the concept, ambit, historical narrative of the parliamentary privileges in a meticulous fashion. Besides, the book brilliantly deals with the powers and functions of Parliament in an exhaustive manner. Moreover, before proceeding further, if this book was available, then I had the opportunity to decide two important questions relating to the Parliament. Of course, the person who introduced me has mentioned latest two decisions rendered on the election side, but I had the opportunity to deliver two judgments relating to the privileges of the members, their duties, etc. When the Parliament NP-led fund was challenged before the Supreme Court by way of Article 32 petition by Mr. Bhim Singh, a leading senior advocate and member of the Parliament, hails from Jammu Kashmir. On his behalf, Mr. Venugopal convinced the bench, it was a constitution bench, and I was a fourth member in that. Then in the afternoon, the present Attorney General, at that time he was a Solicitor General, he took us through various provisions, privileges, etc. Then he concluded his argument at 4 o'clock. Thereafter, it is the practice, whenever we heard any important issue, the meeting was held at the chamber of the then Chief Justice of India. Smelling a clue from my statement, the Honorable then Chief Justice of India asked me to prepare a judgment. Though in a constitution bench I was a fourth member, I had the opportunity to prepare that judgment. For information, like a member of the bar arguing before the court, I spent half an hour to 1 hour to convince both the brother judges. Then very difficult. Ultimately, I convinced all the 4 judges, and it has come as a unanimous decision. Why I am saying, see, they have, the Constitution itself provides enormous powers to them. The judiciary and executive and the elected representatives have a separate field. Why should we interfere? Unless if they exceed their limit, violate a statute, violate our Constitution, we can. That was my attitude, and ultimately all the 4 judges have agreed, and that is the reason now our members of the Parliament and the legislatures are spending, now it is 5 crores per year, and I hope that money is being spent to their own elected representatives in the constituency. And likewise, now this book was, at that time it was not available. I took the assistance and collected several materials only for that. And the other, the person has also mentioned about the freebies judgment. in Tamil Nadu, if you have a valid family card or ration card, you can get everything free of cost. In the Lifetime saying, everything means for the benefit of the people. For example, I mentioned that the directive principles of our constitution mandates the state governments to provide several facilities on education, development of rural areas, health, so many things. So several states taking clue from these directive principles in order to bring the women folk or rural persons from rural area below poverty line. They sponsored many schemes. Though I pointed out that certain things are not permissible, but if we strictly construe the mandates provided in the directive principles, giving a free cycle to a girl student to make her to go to school, giving a free pass to girls to travel in the government buses, free textbooks, free health checkup, etc. We cannot say these are all, these may corrupt the people at the time of election. So I approached in such a balanced way, but of course at the end we requested the election commission to monitor and decide certain things. That's why now in the ensuing election also, this I read it in the newspaper, the election commission has framed some more guidelines to control these political parties. And the present book gains its momentum as it incorporates an objective study on the approach of the judiciary in adjudicating cases involving parliamentary privileges. Constructive relationship between three arms of government, the executive, the legislature and the judiciary are essential to the effective implementation of the objective envisaged in the constitution and to uphold the rule of law in the country. In recent years, an image of tug-of-war between judiciary and parliament is being painted. Of course, a certain degree of tension between three arms of government is inevitable and in fact healthy, because from time to time the judiciary is called upon to adjudicate under the judicial review and on actions of the executive and acts enacted by parliament. Stopping here, unfortunately nowadays our media friends immediately flash their news whatever the interaction between the judge and the members of the bar. It is not the decision of the court. Ultimately they have to see the orders being passed or ultimate judgment we pass in the matters. In order to get more information or get clarification, it is the duty of the court to ask several questions. Side by side we also express certain views. Immediately because of the lot of competition, from the dais I used to note some reporters immediately rush go out because they are keeping their vehicles outside the Supreme Court, and the scroll will come even before we rise for the day. The judge has passed this order, noted this. Ultimately, if we pass an order, you are free to convey it to the public. And coming to our subject, the key to harmonious relations among the arms of government is ensuring that judiciary, legislative and executive do not encroach upon each other's jurisdiction. However, there may be times when there is overlapping, then the ultimate objective of the proposed act must be seen and not necessarily who is superior to whom. The core theme of democracy is to debate on the contentious issues and resolve them in the best interest of the people. Thus, it is always relevant to recall at the times of crisis that in India, Parliament is not supreme, nor judiciary, nor the executive, but the Constitution and the ideals in it. which alone is supreme. The fourth estate of democracy is the media. As two branches of democracy, the media and parliament need each other and the public needs both. The contribution of both parliament and the media to democratic governance cannot be understood. Both play an integral role in the development of an informed society and for upholding the public's right to know. Predominantly, good working relationship between parliamentarians and journalists is essential if both are to fulfill their duties. Thus, it is a sine qua non for efficient democracy. Along with the parliament, the media shares a responsibility to contribute to political, economic and social development in ways consistent with democratic principles by pursuing fact-based, fully substantiated reporting. Thus, in today's free world, freedom of press is essential requisite of a truly functioning democracy. The chapter 10 of this book cogently brings forth this aspect by highlighting the need for the balancing effort to reconcile the privileges of the media and the parliament. The author, a busy law professional in the apex court, deserves great admiration for this impressive, insightful work. Amidst an innumerable to-do list of practicing lawyer, the author's efforts to find time for research and writing a book is a matter of surprise and earns immense appreciation. What comes through his writing is his deep and enduring commitment to law. The meticulous research and reasoned, eloquent comments on this vast field of law evidences the firm grip of the author on the constitutional foundations. Other members of this profession must emulate the efforts of the author. I once again congratulate Dr. K. Chauhan for his painstaking and erudite work. It would not be a hyperbole to state that this book is truly a storehouse of rare and important information surrounding the Parliament. I am confident this book will be read widely and particularly by law professionals, parliamentarians, aspiring lawyers and students who will appreciate the comparative study undertaken by the author on constitutional perspective on powers, functions, privileges of Parliament. I wish him many more years of creativity and scholarly involvement. I give my good wishes for the success of the book. Thank you very much.
Thank you, sir, for sharing your valuable thoughts. I would now...
And how good the content is. But these numbers are reflective of the kind of energy and effort which goes into construction of a book. 15, 18, 8 and 800. It took 15 months and 18 days to actually do this book. It is an 800-page book and it took 8 weeks of editorial effort to bring it to all of you. What is also very important is, I was listening to Justice T.S. Thakur. Legal writing is very, very different than normal writing. I think all of you are aware of it. It requires a degree of precision which is almost equal to probably the instrument which a doctor uses in the operation theatre. Writing a legal book and knowing law is two things which is very, very different. And we have seen this in the writing of Dr. K.S. Chauhan, that the precision required to publish a book like this is existing in this book.
It is said that of wisdom of our ages and the wisdoms that we will pass on to ages to come will reside in our books. It really doesn't matter which medium the book will be, iPad or Kindle, but it will be in our books. Wisdom will be carried through. I hope, pray and wish that for generations to come, when it comes to looking at Parliament and what it stood for, what it stands for and what it will be standing for, this book will be very crucial in reading. I want to thank Honorable Chief Justice of India for gracing this occasion. Thank you, sir. Honorable Justice T.S. Thakur, sir, it was pleasure hearing you, and it was really beautiful speech. And it really did. Three of my gurus are here in this room. Dr. Ranbir Singh sitting right here, Dr. Vijay Kumar and Dr. Jaiswal here. We've been knowing each other for some time, especially Dr. Ranbir Singh. It's always a pleasure to listen to him. Thank you so much, sir, for being here. It is an honor always to have people from the judiciary and academia come together to discuss. Dr. Sir, thank you so very much. I am just when I heard you, I understood what this book really meant after even interacting with Dr. Saab for almost 2 to 3 years. Thank you very much, sir. As this book is now in the market, we are almost through with our stock, sir. The first run is over, and interestingly enough, we are now waiting for the second round of orders to come in. We have, though, saved a few books and it's available outside. You can go out, and we have requested Dr. Chauhan to sign it for you. So it's right outside, and after the event you can collect it. On behalf of LexisNexis and Dr. K.S. Chauhan, thank you so much for being here, and it was a pleasure talking to you all of you today. Thank you.